Hello and welcome to Bar10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Lesson number 64. Let's get right into it with question number 1. John Doe, the owner of a milk container manufacturing firm, sought to focus public attention on the milk packaging law of the state of Clinton in order to have it repealed. On a weekday at 12 noon, he delivered an excited, animated, and loud harangue on the steps of the Capitol in front of the main entryway. An audience of 200 onlookers who gathered on the steps heckled him and laughed as he delivered his tirade. Doe repeatedly stated, gesturing expressively and making faces, that the goddamn milk packaging law is stupid and that I will strangle every one of those G-damned legislators I can get a hold of, because this law they created proves they're all too dumb to live. After about 15 minutes, Doe stopped speaking and the amused crowd dispersed. There are 3 relevant statutes of the state of Clinton. The first statute prohibits all speech-making, picketing, and public gathering of every sort on the Capitol steps in front of the main entryway between 7:45 a.m. and 8:15 a.m., 11:45 a.m. to 12:15 p.m., 12:45 p.m. to 1:15 p.m., and then 4:45 p.m. to 5:15 p.m. on Capitol working days. The Capitol Step statute is probably A, constitutional both on its face and as applied to Doe. B, constitutional on its face but unconstitutional as applied to Doe. C, unconstitutional on its face because it applied to all working days. Or D, unconstitutional on its face because it concerns the state capitol. Take a few seconds and choose the best answer now. I hope you got this one. This was almost a gimme. It should have been option A, constitutional both on its face and as applied to Doe. A content-neutral place, time, and manner restriction of speech must serve an important governmental interest, be narrowly tailored to that governmental interest, and leave an open alternative channels for communication in order to be constitutionally valid. Here, the statute on its face seems to be a content-neutral statute. Place, manner, speech restriction because it prohibits all speech making of every sort, regardless of the type, on the Capitol steps during 4 30-minute intervals on working days. The government interest here is likely to keep foot traffic at a minimum, or safety, or some of the sort, because those may be times when some of the politicians are moving in and out, or traffic. So as a result, these 30-minute intervals might correspond to times that people normally arrive for work, break for lunch, return from lunch, leave for work. The restriction is narrow because the times are only 30 minutes for each of the total of 2 hours on a working day, or about 25% of the entirety of the 8-hour working day. There are alternative channels open because every other time of the working day is available for speech, and there's no restriction during non-working days. The facts do not show the statute being misapplied to Doe because he was making a speech on the Capitol steps at noon, which is one of the restricted times. Therefore, the Capitol Step statute is probably constitutional, both on its face and as applied to Doe. Let's look at options B through D. B, constitutional on its face, but unconstitutional as applied to Doe. I'm not certain why it would be unconstitutional as applied to Doe, because he does fall within that time frame. So the only argument theoretically could be that the time frame is unconstitutional in and of itself. However, given the fact that we're only looking at about 25% of the day and 75% of the day is in fact fully open for this type of behavior, then it is very difficult to make an argument of constitutionality, especially given the fact that we're looking at a very broad type, all language being prohibited during that time frame, all protesting, etc. If the statute said something else and noted a specific type of speech, we're in an entirely different world. C, unconstitutional on its face because it applied to all working days. Not sure that's a very good argument in any case. Again, we're looking at the content. The content is all content is being limited. It's not specific content. And we have a very strong limitation to working days and set times within those working days. So the fact that this is a limitation for working days only seems to be that there's a very clear indication that there is some governmental interest for limiting those timeframes. D, unconstitutional on its face because it concerns the state capitol. Not sure what the argument is here, but the reality is that there can, of course, be limitations on any state buildings. The mere fact that it is a state building does not grant unlimited access to that building, and the rule still equally applies. As a result, A is the only viable and valid answer. Question number 2. Mural, a wallpaper hanger sent Jenny Bell, a general contractor. This telegram will do all paper hanging on new doctor's building per owner specifications for $14,000 if you accept within reasonable time after main contract awarded. Signed, Mural. 3 other competing hangers sent Jenny Bell similar bids in the respective amounts of $18,000, $19,000, and $20,000 respectively. Jenny Bell used Mural's $14,000 figure in preparing and submitting her own sealed bid on the doctor's building project. Before the bids were opened, Mural truthfully advised Jenny Bell that the former's telegraphic subbid had been based on a $4,000 computational error and was therefore revoked. Shortly thereafter, Jenny Bell was awarded the doctor's building construction contract and subsequently contracted with another paper hanger for a price of $18,000. Jenny Bell now sues Mural to recover the $4,000 difference. Which of the following, if proved, would be the best support for Mural's defense? A. Jenny Bell gave Mural no consideration for an irrevocable subbid. B. Mural's subbid expressly requested Jenny Bell's acceptance after awarding of the main contract. C. Even after paying $18,000 for the paper hanging, Jenny Bell would have made a net profit of $100,000 on the doctor's building contract. Or C, before submitting her own bid, Jenny Bell had reason to suspect that Mural had made a computational mistake in figuring his subbid. Take a few seconds and choose the best answer now. If you chose option D, you'd be right. I hope you did, and we're off to a great winning streak here. D. Before submitting her own bid, Jenny Bell had reason to suspect that Mural had made a computational mistake in figuring his subbid. A mistake by only one party is not sufficient to void a contract unless the other party knew or should have known of the other party's mistake. In this case, Jenny Bell had 3 other subbids in the respective amounts of $18,000, $19,000, and $20,000 respectively. Mural's subbid of $14,000 was a huge $4,000 under the lowest of the 3 subbids. If Jenny Bell knew or should have known that Mural's notably lower bid indicated a mistake in the bid, then the contract would be void. Therefore, Mural's defense would be best supported if it is proven that before Jenny Bell submitted her own bid, she had reason to suspect that Mural had made a computational mistake in figuring out his subbid. Let's look at the 3 other options and see why they may not be as good. A. Jenny Bell gave Mural no consideration for an irrevocable subbid. This, in fact, makes very little sense because at the end of the day, there is a contract. The contract was, and the consideration given in that contract was that one person would do work for the other for a set amount of fee. So A is not likely a very good answer. B, Mural subbid expressly requested Jenny Bell's acceptance after awarding of the main contract. Well, it seems as if that occurred, right? Because she moved on and sought the work to be done. Now, the fact that Mural was not available any longer to do the work, but however her bid was based on the Mural subbid, is quite possibly arguably a reason for there to be a claim. There are definitely better arguments to be made on the part of Mural, such as the fact that Jenny Bell could have withdrawn her bid, right? That would be a much more valid argument. C, even after paying $18,000 for the paper hanging, Jenny Bell would make a net profit of $100,000 on the doctor's building contract. That is as irrelevant as it could possibly be. The issue is not what profit Jenny Bell would make, but was the contract violated, and if you could make $104,000 as opposed to $100,000, that is technically and theoretically a loss, right? Regardless of what your profit ultimately may be. It could have been $1 million, and arguably this claim would still have its own merit separate and apart. It's not an issue as to what the profit margin would have been. Question number 3. Lawyers Abel and Baker are the members of the law partnership of Abel and Baker in a small town that has only one other lawyer in it. Abel and Baker do a substantial amount of personal injury work. Client was severely and permanently injured in an automobile collision when struck by an automobile driven by motorist. Client employed the Abel and Baker firm to represent them in obtaining damages for her injuries as a result of that accident. At the time client employed Abel and Baker, the statute of limitations had 6 weeks to run on her claim. The complaint was prepared but not filed. Abel and Baker each thought that the other would file the complaint. The statute of limitations ran on client's claim against motorists. Client has filed suit against Abel and Baker for negligence. That case is on trial with a jury in a court of general jurisdiction. In addition to proving that Abel and Baker were negligent, client must establish as a minimum that she, A, would have, but for her lawyer's negligence, recovered from motorist, B, had a good faith claim against motorist that was lost by her lawyer's negligence, C, was severely and permanently injured when struck by motorist automobile, or D, did not negligently contribute to the failure to have the complaint filed. Take a few seconds and choose the best option now. I hope you chose option A. We're 3 for 3 right now, right? Option A, would have, but for lawyer's negligence, recovered from motorist. To establish a prima facie case of negligence, please remember that you have to show a duty, a breach of that duty, causation, and then actual damages. The standard of care for professionals or someone with special occupational skills is to act with the level of knowledge and skill that is commonly possessed by members of the profession or occupation in good standing in similar communities. Here, Abel and Baker were attorneys for client, but they did not file the complaint before the statute of limitations ran on client's claim against motorists. The standard of care owed to client is to act on the level of attorneys in good standing in similar small towns, which at the very least would include timely filing of complaints. By not doing so, they breached their duty to client. Client must also establish, however, that because of that breach, she suffered some damage. It's not enough to simply have a good faith claim that never had a chance to be heard in court due to her attorneys negligently failing to file the complaint. Please remember that it is required that there is an actual injury. Client must show that her attorney's negligence caused her damages by establishing that, but for her attorneys failing to file the complaint, she would have recovered from motorists. So as a result, A is the best option. B, had a good faith claim against motorists that was lost by her lawyer's negligence. A good faith claim is not enough. A good faith claim is the majority of claims that are presented. That being said, the majority of claims that are presented doesn't necessarily mean that the majority of claims that are presented are in fact valid, viable claims. That's why we have an entire basis for dismissal motions, for summary judgment motions, right? That's why those functions exist. C, was severely and permanently injured when struck by motorist automobile. Now, that's very interesting. It's a bit tricky. It's terrible that she would have been injured or horribly injured, but that being said, the issue is not whether she was injured and not whether what damages she received to her body or physically. The issue is, did she in fact have a claim? Just because there's a greater injury doesn't necessarily mean there is a claim in fact, right, or in law. So that being said, C is not a viable option. D, did not negligently contribute to the failure to have the complaint filed. Again, we're talking about legal malpractice. We're talking about the attorney not meeting their obligation. The contribution of the client is generally not relevant unless the client, in fact, failed to present or sign documentation that was necessary for the submission. I would find it very hard to make D a possible choice here. So you'd be left with A and only A as the very best answer. Question number 4. Paula sued for injuries she sustained in a fall in a hotel hallway connecting the lobby of the hotel with a restaurant located in the very same hotel building. The hallway floor was covered with vinyl tile. The defendants were Horn, owner of the hotel building, and Lee, lessee of the restaurant. The evidence was that the hallway floor had been waxed approximately an hour before Paula slipped on it, and although the wax had dried, there appeared to be excessive dried wax caked on several of the tiles. Holmes' defense was that the hallway was part of the premises leased to Lee, over which he retained no control, and Lee denied negligence and allegedly contributory negligence. Lee offered to prove by Marks, the restaurant manager, that in the week immediately preceding Paula's fall, at least 1,000 people had used the hallway in going to and from the restaurant, and Marks had neither seen anyone fall nor received reports that anyone had fallen. The trial judge should rule that this evidence is A, admissible because it tends to prove that Paula did not use the care exercised by reasonably prudent people. B, admissible because it tends to prove that Lee was generally careful in maintaining the floor. C, inadmissible because Mark's testimony is self-serving. Or D, inadmissible because it does not bear on the issue of Lee's exercise of due care on this specific occasion. Take a few seconds and choose what you believe to be the best answer now. I hope you chose option D. You should have. If you'd been with us long enough, you definitely would have noticed that D would be the only viable answer. Let's take a look at why. D, inadmissible because it does not bear on the issue of Lee's exercise of due care on the specific occasion. Logically relevant evidence is any evidence that has a tendency to make the existence of any fact that is of consequence to the determination of the action more or less probable than it would be without the evidence. In this case, the floor had been waxed approximately an hour before Paula slipped on it. The evidence about Marks not seeing anyone fall or not receiving reports of anyone falling in the week preceding Paula's fall doesn't really affect the probability of the floor being negligently waxed the hour before Paula slipped on it. As such, the trial judge should rule this evidence inadmissible because it does not bear on the issue of Lee's exercise of due care on this specific occasion. Let's look at options A through C. A, admissible because it tends to prove that Paula did not use the care exercised by a reasonably prudent person. Untrue. The evidence is actually, in fact, irrelevant because as of an hour prior to the fall, the condition of the hallway had changed. B, admissible because it tends to prove that Lee was generally careful in maintaining the floor. Again, not relevant. There is no maintenance of the floor. Remember that the condition was changed just an hour before the fall. So there is not an issue of long-term maintenance over the week before. That time frame is, in fact, completely irrelevant. C, inadmissible because Mark's testimony is self-serving. Horrible answer. For the most part, as a judge, any testimony that you hear is generally going to be self-serving. Think about it this way. You're hearing a divorce case. Do you not think that both parties are going to be giving self-serving evidence? Of course they will. The job of the trier of fact is to process this self-serving testimony and then base a decision. That being said, A, B, and C are not viable options. D is without question the very best option here. Okay, let's hit that halfway mark Question number 5. Defendant visited a fellow college student, James, in James's dorm room. They drank some beer. James produced a box containing marijuana cigarettes and asked if the defendant wanted one. Defendant, afraid to be caught, declined and urged James to get rid of the marijuana. James refused. Shortly thereafter, both went out to get more beer, leaving the door to James's room standing open. Making an excuse about having dropped his pen, defendant went back into James's room. Still apprehensive about their being caught with the marijuana cigarettes, he took the cigarettes and flushed them down the toilet. He was sure James was too drunk to notice that the cigarettes were missing. Defendant is charged with larceny and burglary, defined in the jurisdiction as breaking and entering the dwelling of another with intent to commit any felony or theft. He should be found guilty of A. Burglary only, B. Larceny only, C. Both burglary and larceny, or D. Neither burglary nor larceny. Take a few seconds and choose what you believe to be the best answer now. I hope you chose option B, larceny only. Larceny is the wrongful taking and carrying away of another's tangible personal property without consent and with the intent to permanently deprive. Burglary, as defined here, is breaking and entering the dwelling of another with intent to commit a felony therein. Here, James's door was open, so there was no breaking and entering. Once inside James's dorm, defendant took James's marijuana cigarettes without consent and flushed them down the toilet. Flushing the cigarettes down the toilet demonstrates defendant's intent to permanently deprive James of his personal property. Thus, defendant should be found guilty of larceny only. Now, let's take a little bit of a deeper dive into this question. If the possession of marijuana were illegal in your jurisdiction, then it's very unlikely that this claim would have been brought to begin with. That being said, things seem to be changing in many locations, and it may be possible that you see cases more like this in the future. But that being said, for a very long time, you would have never heard a case like this. Let's look at the other options. A, burglary only. Incorrect. There was no breaking and entering. C, both burglary. X, not a viable option. D, neither burglary. We're good there. It wasn't a burglary nor larceny. That's where D fails. Definitely there was a larceny here. There was a taking with an intent to permanently deprive, as flushing something down the toilet is generally considered deprivation of that property. You're not likely to see that property again. So as a result, only B is a viable option here. Question number 6. On March 1st, Zeller orally agreed to sell his land homestead to buyer for $46,000 to be paid on March 31st. Buyer orally agreed to pay $25,000 of the purchase price to Quincy in satisfaction of a debt which Zeller said he had promised to pay Quincy. On March 10th, buyer dictated the agreement to his secretary but omitted all of the references to the payment of the $25,000 to Quincy. In typing the agreement, the secretary mistakenly typed in $45,000 rather than $46,000 as the purchase price. Neither buyer nor Zeller carefully read the writing before signing it on March 15th. Neither noticed the error in price, and neither raised any question concerning omission of the payment to Quincy. If buyer refused to pay more than $45,000 for homestead in an action by Zeller against buyer for an additional $1,000, it would be to Zeller's advantage to try to prove that A, the writing was intended only as a sham, B, the writing was only a partial integration, C, there was a mistake in integration, or D, there was a misunderstanding between Zeller and buyer concerning the purchase price. Take a few seconds and choose what you believe to be the correct answer now. The correct answer is C. There was a mistake in the integration. Remember that the parole evidence rule states that no prior expressions, written or oral, or contemporaneous oral statements are admissible that contradict the final integration between the parties. Parole evidence is generally inadmissible to contradict or change the writing of a contract or the writing within a contract. However, parole evidence is admissible to show a mistake in integration or a clerical error of sorts. An integration is a written agreement intended to be the final contract between the parties. In this case, the secretary mistakenly typed in $45,000 rather than $46,000 as the purchase price. This is a mistake in integration by a clerical error by the receptionist. Parole evidence of the $46,000 oral agreement made before the secretary typed up this agreement and made the error is, as a result, then admissible. As such, it would be to Zeller's advantage to try to prove that there was a mistake in the integration in the error by the receptionist. Let's look at the three other options, A, B, and D. A, the writing was intended only as a sham. Not a very good argument. Ultimately, you're pretending that the entirety of the contract was intended to be a fraud. Not a great position to take either way, period. B, the writing was only a partial integration. The problem here is that the price was integrated, right? So the number was already integrated. So if it were not integrated in, you could theoretically make that argument, but it was. So B is not a viable option. D, there was a misunderstanding between Zeller and buyer concerning the purchase price. There was no misunderstanding. That would be an improper argument. The issue was the integration or the inclusion of the correct information in the finalized contract. So as a result, C is without question the very best answer here. Question number 7. Paula sued for injuries she sustained in a fall in a hotel hallway connecting the lobby of the hotel with a restaurant located in the hotel building. The hallway floor was covered with vinyl tile. The defendants were Horn, owner of the hotel building, and Lee, lessee of the restaurant. The evidence was that the hallway floor had been waxed approximately an hour before Paula slipped on it, and although the wax had dried, there appeared to be excessive dried wax caked on several of the tiles. Horn's defense was that the hallway was a part of the premises leased to Lee, over which he retained no control, and Lee denied negligence and alleged contributory negligence. If Paula offered to prove that the day after she fell, Horn had the vinyl tile taken up and replaced with a new flooring cover, the trial judge should rule that the evidence is A, admissible because it is relevant to the issue of whether Horn retained control of the hallway, B, admissible because it is relevant to the issue of awareness of the unsafe condition of the hallway at the time of Paula's fall. C, inadmissible because there was no showing that the new flooring covering would be any safer than the old. D, inadmissible because to admit such would discourage a policy of making repairs to prevent further injury, regardless of fault. Take a few seconds and choose what you think is the right answer now. The correct answer here would be A, admissible because it is relevant to the issue of whether Horn retained control of the hallway. Evidence of subsequent remedial measures or repairs after an accident is inadmissible generally to prove culpable conduct or that the defect in the actual item was the cause of the injury or liability. However, such evidence is admissible to prove anything else, such as control of the premises. Here, Paula brought a negligence claim against Horn and Lee. Horn's defense was that he had no control over the hallway where the accident occurred. Paula wanted to offer evidence that on the day after she fell, Horn replaced the floor covering in the hallway. If Horn's action was undertaken to prevent future falls, it is a subsequent remedial measure. Therefore, the evidence is inadmissible to prove that Horn breached his duty of care, but it is admissible for all other purposes. The next step in the analysis is understanding why Paula was offering the evidence. In answer choice A, for example, Paula offered the evidence to refute Horn's defense that Lee controlled the hallway. Therefore, the trial judge should rule that the evidence is in fact admissible because it is relevant to the issue of whether Horn in fact actually retained control of the hallway. Note that if Horn had not disputed his control of the hallway, the evidence would likely then be inadmissible because it could only be presented for one issue, and that would be liability. Cannot be presented for that. B, let's look at that. Admissible because it is relevant to the issue of awareness of the unsafe condition of the hallway at the time of Paula's fall. Again, this is more of a liability issue. Can't bring it in for that. Can't bring it in to show liability or consciousness of liability. C, inadmissible because there was no showing that the new flooring covering will be any safer than the old. This is as irrelevant as I could possibly imagine. So C's out. D, inadmissible because to admit such would discourage a policy of making repairs to prevent further injury regarding a fault. That is a great point, and if you're going to get confused on this question, that would be the one to choose if you're confused. Remember, however, that the issue here is not that we're aiming to present evidence for the sake of liability, which you can't do, but what you can do is you can present evidence to show that the statement of lack of control of the hallway is inaccurate. That is fully permissible. As a result, A is the best answer here. Question number 8. While the defendant was in jail on a procuring charge, his landlord called the police because rent had not been paid and because he detected a disagreeable odor coming from defendant's apartment into the hallways. The police officer who responded to the call knew that the defendant was in jail. He recognized the stench coming from the defendant's apartment as that of decomposing flesh, and without waiting to obtain a warrant and using the landlord's passkey, entered the apartment with the landlord's consent. The lease to these premises gave the landlord a right of entry at any reasonable hour for the purposes of making repairs. The police officer found a large trunk in the bedroom which seemed to be the source of the odor. Upon breaking it open, he found the remains of Rosette, defendant's former mistress. The landlord's consent to the police officer's search of the defendant's apartment is A, a waiver of defendant's Fourth Amendment rights because the landlord has implied consent to enter a tenant's apartment. B, a waiver of tenant's Fourth Amendment rights because the lease gave the landlord express authority to enter the premises. C, not a waiver of defendant's Fourth Amendment rights because the landlord lacked probable cause to believe a crime was then in the process of being committed. Or D, not a waiver of defendant's Fourth Amendment rights because the landlord had neither actual nor apparent authority to permit the entry. Take a few seconds and choose what you believe to be the best answer now. If you chose option D, you'd be right, and I'm certain that you're on a roll and a winning streak here, and you're 8 for 8. Good for you. D, not a waiver of defendant's Fourth Amendment rights because the landlord had neither actual nor apparent authority to permit the entry. Remember that the Fourth Amendment prohibits unreasonable searches and seizures. Unreasonable searches and seizures have been deemed to be those involving state action that intrude upon an individual's reasonable expectation of privacy. The Fourth Amendment is satisfied where a warrant has been issued, but in certain situations, an investigatory search may take place without that warrant. For example, the police may search without a warrant if the suspect gives voluntary and intelligent consent to that search. If a third party gives consent, the search is valid even if the consenting party did not actually have the authority to consent, as long as the police reasonably believed the party consenting had the authority to do so. Yeah, think that one through. Here, the landlord had authority to enter the defendant's apartment for the purpose of making repairs. The landlord did not, however, have authority to consent to the officer entering the defendant's apartment, unless he was making repairs. Furthermore, It was not reasonable for the officer to believe the landlord had the authority to consent to a search of the defendant's apartment. The officer knew the defendant was in jail, and the officer used the landlord's passkey to enter the defendant's apartment. As such, the landlord's consent was not a waiver of the defendant's Fourth Amendment rights, because the landlord had neither actual nor apparent authority to permit the entry. Without question, D is by far the best answer here. Let's look at A through C, however. A waiver of defendant's Fourth Amendment rights because a landlord has implied consent to enter a tenant's apartment. Well, he does, but for limited purposes, as we're told in the call of the question. Only for repairs. There's no repairs involved here. You have a subsequent issue. Even if there was a possibility of entering the apartment for the repairs, you have the secondary locked mechanism of the box itself, right? Because the box was locked, and the lock had to be destroyed in order to open the box. So you have multiple issues. You have multiple layers here. As a result, A would not have been possibly correct. B, a waiver of defendant's Fourth Amendment rights because the lease gave the landlord express authority to enter the premises. Again, same limitation. Express authority only to enter for the purposes of repairs. The same analysis that we did for A is relevant here for B. C, not a waiver of defendant's Fourth Amendment rights because the landlord lacked probable cause. Whoa, let's stop right there. Landlord doesn't need probable cause. He's not a state actor. He's not a police officer. He is not required to have probable cause to take any action to believe that a crime was then in the process of commission. Even if the individual had probable cause, or what's deemed probable cause, as he being not a police officer or not as agent of the state, he has no right to take any further subsequent action. So D is not relevant or appropriate. A, B, and C, not viable at all. D would be your only viable and correct choice here. Question number 9. While negligently driving his father's uninsured automobile, 25-year-old Arthur crashed into an automobile driven by Betty. Both Arthur and Betty were injured. Charles, Arthur's father, erroneously believing that he was liable because he owned the automobile, said to Betty, "I will see to it that you are reimbursed for any losses you incur as a result of the accident." Charles also called physician and told him to take care of Betty, and that he, Charles, would pay the bill. Arthur, having no assets, died as a result of his injuries. Dodge, one of Arthur's creditors, wrote to Charles stating that Arthur owed him a clothing bill of $200 and that he was going to file a claim against Arthur's estate. Charles replied, "If you don't file a claim against Arthur's estate, I will pay what he owed you." In an action by Betty against Charles for wages lost while she was incapacitated as a result of the accident, which of the following should be Charles's best defense? A, lack of consideration. B, mistake of fact as to basic assumption. C, the statute of frauds. Or D, indefiniteness of Charles's promise. Take a few seconds and choose the correct answer. I hope you chose option A, lack of consideration. The rule is that a valid contract must have an offer, acceptance, consideration, and no defense to the formation of that actual contract. Consideration is the bargain for exchange between two parties or the parties to a contract. Any legal detriment or forbearance, as well as actual benefits and performance, can constitute consideration. In this case, Charles, Arthur's father, who erroneously believed that he was liable because he owned the car driven by Arthur, said to Betty, "I will see to it that you are reimbursed for any losses you incur as a result of the accident." However, since this promise by Charles is not supported by any consideration on the part of Betty, there is no bargain for consideration and therefore no exchange. Therefore, there is no contract as a result. As such, Charles's best defense would be a lack of consideration because it would lead to no contract. B, mistake of fact as to a basic assumption. B, mistake of fact, especially a unilateral mistake of fact, is generally not a basis to invalidate a contract. C, statute of frauds. Probably not a very good choice because simply the statute of frauds is very unlikely to apply under these circumstances. And D, indefiniteness of Charles's promise. This is not a rule against perpetuities case. This is not a rule against perpetuities situation. B, C, and D are out. A, lack of consideration. That's all you have, and that is the correct answer. Question number 10. While defendant was in jail on a procuring charge, his landlord called the police because rent had not been paid and because he detected a disagreeable odor coming from defendant's apartment into the hallways. The police officer who responded to the call knew that defendant was in jail. He recognized the stench coming from defendant's apartment as that of decomposing flesh and, without waiting to obtain a warrant and using the landlord's passkey, entered the apartment with the landlord's consent. The lease to the premises gave the landlord a right of entry at any reasonable hour for the purpose of making repairs. The police officer found a large trunk in the bedroom, which seemed to be the source of the odor. Upon breaking it open, he found the remains of Rosette, defendant's former mistress. If defendant undertakes to challenge the search of his apartment, he has A, standing because the items seized in the search were incriminating in nature. B, standing because he still has a sufficient interest in the apartment even while he is in jail. C, no standing because his landlord authorized the search. Or D, no standing because he was out of the apartment when it occurred and not paid his rent. Take a few seconds, choose the best answer now. This should have been a gimme here. The correct answer would be B. He does have standing because he still has a sufficient interest in the apartment even while he is in jail. The Fourth Amendment, remember, prohibits unreasonable searches and seizures. Unreasonable searches and seizures have been deemed to be those involving state action that intrude upon an individual's reasonable expectation of privacy. The purpose of the Fourth Amendment is to prevent police and law enforcement misconduct in investigations. A defendant must have standing to challenge governmental action, which occurs if the defendant has a reasonable expectation of privacy in the item or place searched. The Supreme Court has found automatic standing where the search takes place in a suspect's home, in a place owned by the suspect, or where the suspect is an overnight guest of the owner of that place. In this case, the officer entered and searched defendant's apartment while defendant was in jail without a warrant or a valid exception to the warrant requirement. The defendant's reasonable expectation of privacy in his apartment did not cease once he was in jail, so the defendant still had automatic standing to challenge the officer's search. Thus, if defendant undertakes to challenge the search of his apartment, he has standing because he still has a sufficient interest in the apartment even while he's in jail. So let's look at the other options and see why they would not be correct. Let's start with the last option, option D, no standing because he was out of the apartment when it occurred and had not paid his rent. So we have two issues here, out of the apartment and not paid his rent. The fact that he has not paid his rent is not relevant. He still remains as a possessor and having a property interest in the property until there's a judgment of eviction issued. So unless that had happened, the likelihood of there being a lack of property right to consent to the search is probably non-existent, and so D would not be a viable option. C, no standing because his landlord authorized the search. Remember, landlord cannot authorize the search. Landlord is not able to authorize the search. He can only permit entry for himself and or other subordinates for the issue of repairs. There is no question of repairs here, so C is out of the question. A, standing because the items seized in the search were incriminating in nature. Now, this is a very interesting choice. This basically says that there is no issue and there is standing because that which was found was actually incriminating in nature. So if there had been nothing incriminating found, arguably you'd say there would be no standing. Well, there would be no need for standing because there would have been no evidence to lead to the crime. However, that being said, it's logically flawed because the issue here is not of what evidence was secured and what evidence was not secured, but more so, did the defendant maintain a property interest in order to challenge the search of his apartment? And that answer is absolutely yes, until he's been removed of a possessory interest from a court through a judgment of eviction or some sort of removal from the property. If it were an owned home, that would be a foreclosure or something of the sort. Then the likelihood is that the defendant will remain with having a possessory interest and the ability to object to any search of that property, as well as, more importantly to this question, standing in order to do so and make those objections. As always, thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. If you like this content, don't forget to like, subscribe, and ring the notification bell so that you can be updated every time we upload new content. Please also share this content with your friends so that they can be aided in preparing for the bar exam themselves. Thank you.